The decedent died on January 15, 2000, at the age of 91, a resident of 470 Park Avenue, New York City, with an estate valued at approximately $15 million. Her husband predeceased her in 1980. There were no children of the marriage. The identity of her distributees is still in dispute. The closest known surviving relatives are first cousins, 6 of whom are known. 2 reside in the United States and 4 outside in Canada, England, and Holland. On or about March 17, 2000, the executors and petitioners herein offered for probate an instrument dated July 17, 1997, drafted by an attorney. The will made multiple pre-residuary bequests for the benefit of friends, a relative on the decedent's predeceased husband's side of the family, and a named charity, and devised and bequeathed the residue of her estate to an attorney and friend of the decedent and her deceased husband since the early 1970s, who also received substantial residuary bequests. Subsequent to the filing of this instrument, 6 prior wills of the decedent were also filed with the court. Neither the subject will nor any of the prior wills mention the decedent's cousins. In fact, none of the 6 other prior testamentary instruments executed during the period 1977 through 1988 provide for the first cousins. Instead, beginning with the first of these instruments executed on May 26, 1977, through the date of the subject instrument, 11 of the decedent's 13 American wills name Morrissey as either an executor, trustee, or beneficiary of her estate. Notably, in the will dated December 24, 1980, and then again in the 5 wills executed between 1992 and 1997, Morrissey received 100% of the decedent's residuary estate, thus, according to the public administrator, establishing a pattern where Morrissey takes the residuary estate wherever Forsyth drafts the will. The initial petition for probate of the subject will listed as the decedent's only distributee a maternal first cousin, a resident of Los Angeles, California, who initially executed a waiver of citation and consent to probate, but later, on May 26, 2001, appeared by counsel. Subsequent to its filing, the initial petition has been amended 3 times to reflect the discovery of previously unknown additional cousins. With the filing of each amended petition, supplemental citation was issued. A second distributee, a paternal first cousin of the decedent, filed a waiver of citation. The other distributees defaulted. Certain beneficiaries of substantial bequests made under prior wills of the decedent, to wit, members of the family, the Animal Medical Center, and the estate of a former employee of the decedent, who will be adversely affected by probate of the subject will, have filed objections. The public administrator of New York County, on behalf of unknown distributees, also filed objections. The objections assert that on the day of the will's execution, July 17, 1997, the decedent lacked testamentary capacity, that the instrument was not duly executed, and that it was procured by the undue influence and fraud of Morrissey and others acting in concert with him. According to Morrissey and petitioners, all of the decedent's surviving heirs have been located, and thus, with the closing of the class of unknown distributees, the public administrator's interest in the matter has terminated, and her objections have become moot, as she no longer represents persons with a pecuniary interest. The basis for this assertion is an affidavit of a genealogist who has investigated the decedent's family tree. and states that decedent was survived solely by 6 distributees, the first cousins previously mentioned. The public administrator argues that the identity of the decedent's distributees remains unknown among gaping holes in the genealogist's affidavit. The status, for instance, of a sister, Hildebrand, and her daughter, whose name is not even known, as well as that of various aunts and uncles and their issue, has not. The genealogist stated that one of the decedent's cousins had died between 1917 and 2000, an 83-year period, despite the fact that Klaus's sister Lily still is alive and living in Canada and apparently never contacted. It is clarified that, in addition, the genealogist concluded that one of the cousins died before 2000, conveniently, as the public administrator argues, before the decedent's death in January 2000, arguing that there was no unknown distributees and that the 6 distributees identified by the genealogist either waived citation or defaulted. Morrissey moved to strike the public administrator's objections to probate on the ground she lacked standing pursuant to the provisions of SCPA 1410. Morrissey further argued that the public administrator's standing could not be based on any purported right to serve as fiduciary, inasmuch as 2 of the decedent's distributees were United States residents who, in the event that all 15 of the decedent's wills were denied probate, are eligible to serve as administrators. Okay. Too fast.
It's too fast. He's once